In this lecture, we'll consider the scope of judicial review, and what that means is essentially how hard is the court going to take a look at agency decisions. And here we're going to be focusing on the legal phrase, committed to agency discretion. Let's talk a little bit about discretion, because some things that an agency does are mandatory, and if things are mandatory, then they are subject to judicial review. In other words, if there's something that an agency is supposed to have done, or if there's a particular way in which they are supposed to have done it, and the allegation is that they have failed to do that, then judicial review is always available, meaning you can always go to court and sue. But if an action is discretionary, it's usually not. There are many instances in which the law leaves the agency a choice of how it's going to implement something or what it chooses to do. And in instances such as that, judicial review is usually foreclosed. Now, this lecture will be a little shorter than usual because many of these concepts are explored in several cases in your book. And this concept is explored in two cases, Heckler v. Chaney from 1985 involving a death penalty case, and Lincoln v. Vigil from 1993 involving a decision by a federal agency to shift its funding for Native American health. So as usual, I commend these cases to your attention. But with regard to agency discretion, as we've just mentioned, if an action is discretionary, it's usually not reviewable in court, but this raises a really interesting question because even these questions, even the discretionary issues, can be overturned for abuse of discretion. And that creates a little bit of a catch-22 because if discretionary decisions are not supposed to be reviewable, well then who's supposed to review whether or not they are an abuse of discretion? The fact of the matter is the only people that can do that are the courts. So even discretionary decisions can be challenged in court. The only difference is the standard for judging such decisions is much, much lower than the standard for judging those actions that are mandatory. So one case, one early case in which the courts deferred to an agency was in NLRB versus Hearst publications from 1944. And this case involved newsboys, these little boys who would sell newspapers on the corner. And the NLRB determined that newsboys were employees, and that meant they were entitled to collective bargaining rights. Well, their employers, Hearst Publications and other newspapers, didn't like that. They didn't want to have to collectively bargain with newsboys, and so they challenged this determination in court. The court ruled in favor of the NLRB on a 9-0 vote, beginning an extended run of support for agency decisions. Congress entrusted to the agency primarily the decision whether the evidence establishes the material facts. Hence, in reviewing the board's ultimate conclusions, it is not the court's function to substitute its own inferences of fact for the board's when the latter have support in the record. The board's determination that specified persons are employees under the Act is to be accepted if it has warrants in the record and a reasonable basis in law. So as long as it's reasonable, and that should sound familiar to you, we will defer to the agency, and we will do that because that's exactly what Congress wanted us to do. The primary responsibility was entrusted to the agency by Congress, and we should not tamper with that. Another case in which the court explored this concept was Universal Camera Corp versus NLRB, another NLRB case from 1951. And in this case, the NLRB had ordered a fired employee reinstated with back pay. Once again, the court supported the NLRB, saying this court will intervene only in what ought to be the rare instance when the standard appears to have been misapprehended or grossly misapplied. So, as was mentioned in class, this test is very, very similar to the rational basis test that we talked about in the context of discrimination cases. And it's a very friendly standard, obviously, to the government because it defers to them in most instances. So, the abuse of discretion standard is used for those decisions that are committed to agency discretion, and as we've said, that they're going to be overturned only if they're completely irrational, arbitrary, and capricious. However, this standard does not apply in cases that are decided on the record. Courts are sometimes, of course, called upon to decide not only informal actions, but formal actions, those that were supposed to be on the record. And in those instances, the court uses a different standard of review, and that is the substantial evidence standard. Formal rulemaking and adjudication are decided under this standard, and what does that standard mean? Well, the court has said it means that there has to be more than a mere scintilla of evidence. So there is some bar that the administrative agency needs to clear. What that bar is exactly, we do not know, but it has to be more than just a tiny amount of evidence. There has to be some critical mass of evidence that is achieved. And what does that mean? It means such relevant evidence that a reasonable mind might accept as adequate. Now, this is a slightly higher standard than the rational basis standard, although not much, because I think it's very interesting in that these kinds of tests ask people to decide what a reasonable mind might think, and yet everybody thinks their own mind is reasonable, and so this test simply invites judges to substitute their own values for Congress's values or the administrative agency's values. But nevertheless, they're saying that there should be more evidence than is required in a case involving discretion. And of course, as we've mentioned before, it has to be justified only by material on the record. That is certainly one thing that can get an agency decision tossed out, is if they justify it based on things that weren't in the record if it was a formal action. So again, this lecture is fairly short because your book has several cases that illustrate this concept. One is FCC v. Fox, involving a curse word uttered on television by this pair back in the early 21st century. Another famous case, Massachusetts v. EPA, 2007, involving the EPA's rulemaking authority over air pollution. And of course, one of the most famous public administration cases of all time, Chevron versus Natural Resources Defense Council, which we've touched upon in class and in some of the presentations that we've seen. So as usual, I commend these cases to your attention. Another case contained in your book is also City of Arlington v. FCC.